Existing obligations. Can performance of an existing duty which is already owed under a contract constitute consideration? The answer will depend on the circumstances. For example, duties may exist for different reasons, such as some are public duties and some are contractual obligations. The simple issue at the heart of this question is whether doing something you are already obliged to do can legally count as a benefit or a detriment. We will look at three situations. A situation where one has a public duty to perform an act. For example, a police officer providing security to a demonstration. The second situation is where there is an existing contractual obligations owed to a third party. The third situation is where an existing contractual obligation is owed to the promisor. In order to discuss this area of law, we will look at several cases. In Collins versus Godfroy, 1831, the defendant promised the plaintiff 6 guineas to testify in court. However, the plaintiff was subpoenaed, so was obliged by law to attend court. The defendant later on refused to pay. The question here was whether performing a legal duty can be sufficient consideration. If you read the judgment, you will be able to safely assert that this is a public policy issue. The agreement was unenforceable as there had been no consideration. The promise to pay a witness who was already under a public duty to give evidence lacked consideration. The witness did nothing above what he was already obliged to do, and therefore he did not receive or incur a legal benefit or detriment in return for the promised payment. So, does this mean that if the witness had gone above and beyond his legal duties, courts would have found there to be a consideration? On this note, let's look at another case. In Glassbrook Brothers versus Glamorgan, 1925, the defendants, who were the owners of a local coal mine, requested police presence during a strike. The police, who were the plaintiffs in this case, offered a visiting patrol service. They believed that this service would be adequate. The defendants were concerned about site safety and decided that they wanted a stationary on-site presence and agreed to pay for this service. The defendants then refused to pay on the grounds that the police were performing their duty to keep the peace. So, was performance of a public duty sufficient consideration? In this case, it was held that police had gone beyond their existing duties and therefore the defendant should pay for the services rendered. Looking at the facts, the police had gone beyond this duty by providing more protection than they were obliged to do. By exceeding their public duty, the police did something they were not obliged to do and so provided a benefit and incurred a detriment, which amounted to a good consideration. Is it always the case that one has to go above and beyond in performing an existing public duty for it to be constituted as a good consideration? Lord Denning did not think so in the case of Ward versus Byham. Ward versus Byham, 1956. The plaintiff was the mother of an illegitimate child, and she agreed to look after her child well and to allow the child to decide who she wished to live with. In return, the defendant, who was the father, promised to pay maintenance. The defendant then ceased to make payments. The Court of Appeal, in majority decision, decided that the mother had gone beyond her legal duty by allowing the child to decide who she wished to live with, and that this was sufficient consideration. Lord Denning dissented and argued that the factual benefit to the father was sufficient consideration. In Lord Denning's words, "I have always thought that a promise to perform an existing duty or the performance of it should be regarded as good consideration because it is a benefit to the person to whom it is given. Despite the traditional requirement to exceed a non-contractual duty before it can constitute good consideration, Lord Denning suggested that the mere performance of a public duty may sometimes constitute consideration." Lord Denning thought that there was consideration for the promise of the income despite the fact that the mother was already under a statutory duty to look after her child. Do you agree with Lord Denning's views? Tell us what you think. Let's look at Lord Denning's views in another case. In Williams versus Williams, 1957, plaintiff left her husband and he agreed to pay her £1 and 10 shillings per week. In return, she promised to not to pledge the husband's credit and to indemnify him against any debt she incurred. Husband, the defendant, refused to pay arrears. His argument was that the plaintiff provided no consideration because after leaving him, she was not entitled to be maintained by him or to pledge his credit. It was held that plaintiff's promise was good consideration because she had only suspended her rights to be maintained by her husband, as she could return at any time. Lord Denning stated that a promise to perform an existing duty is, I think, sufficient consideration to support a promise so long as there is nothing in the transaction which is contrary to the public interest. This brings us to another question. Why do you think there must be a public policy exception if the performance of a public duty can constitute good consideration? Individuals, especially those in public office, should not be able to extract extra payment for doing or agreeing to do something they are already obliged to do as a matter of public duty. Clearly, there is a danger of corruption or extortion that they may perform in a manner which is more to the benefit of their private paymaster than for the public benefit. Cases such as Collins versus Godfroy can be explained as examples of transactions potentially against public policy. The promise to pay the witness was clearly close to the line separating an honest payment and a bribe.